And yesterday, I think during our colloquium on judicial safe ships, couple of speakers and the discussion, people mentioned the sad destiny of the Rotterdam Rules. And this is an attempt to improve that destiny and to get a happy end for the Rotterdam Rules in the end and put them in practice. So Rectify to Ratify, that is Igor's invention. I think it's a marketing trick to get your attention after the lunch break. This slide is to remind you that the mandatory regulation of carriage by sea commenced more than a century ago with the idea of protecting the shippers against unfair contract terms imposed by the ship owners who, at that time, had the upper hand in deals negotiations. The very same idea has been reverberating through the subsequent international instruments. So under the Hague Rules, who is liable? The carrier and the ship. Who is the carrier? The carrier includes the owner or the charterer who enters into a contract of carriage with a shipper. And after receiving the goods into his charge, the carrier or the master or agent of the carrier shall issue a bill of lading. How does it look in practice? Now, the master or the agent issue the bill of lading to the shipper. Who they represent has to be found out from the terms of the bill of lading, including company's logo printed on it, identity of carrier clause, qualification of the signature, and so on and so forth. Additional question is, has the charterer sufficient assets to pay for the cargo claims, and is the asset accessible or hidden in a bank account or otherwise on a remote tax haven island? Who else is liable? In July 1952, a cruise ship, Himalaya, docked in the port of Trieste. Miss Adler went ashore and, returning to the ship, while walking alongside the gangway, a gust of bora wind moved the ship from the shore. The gangway came adrift from the gantry at the shore end, collapsed, and Miss Adler fell onto the wharf, some almost 5 meters below. She suffered serious injuries. She could not sue the ship owners due to an exoneration clause in her ticket, so she sued the master and the boatswain for negligence in putting up the mooring arrangement and securing the gangway. The ship owners start drafting clauses, called Himalaya clause, after the ship, for protection of their servants. In another celebrated case, the cargo entry sued the stevedores who dropped a drum with chemicals, so the contact leaked. So in order to bypass the limitation, the package limitation, and recover the damage in full, they sued the stevedores. In spite of the clause protecting inter alia, any person to the extent bound by this bill of lading, whether acting as carrier or bailee, The stevedores were denied the privilege of limitation because they were not party to the contract of carriage. Hague Whitby rules gave protection against actions in tort to the charters, to the carriers and his servants, not being independent contractors. Then came the Hamburg Rules. By copying the Aviation Convention, the Hamburg Rules introduced the concept of actual carrier, a party who performs the whole or part of the carriage. The motive of the Aviation Convention was the following. If a passenger has a direct flight from Sydney to Zagreb, he has one carrier. However, if he buys a direct ticket but must transfer in Zagreb, then he has two carriers, the contractual one and the actual one. The idea was to allow him to sue both. Hamburg rules have definition of actual carrier, which is a person to whom the performance of the carriage of the goods or part of it has been entrusted. Now the Rotterdam Rules came. And the Rotterdam Rules copied the COXA draft law of the Carriage of Goods by Sea Act of the United States. The idea was to stop the passing of the national law, which might replace an international convention. And the COXA had this performing party carrier concept. And it means a person that performs, undertakes to perform, or procures to be performed any of a contracting carrier's responsibility under the contract of carriage. So the CMI copied that definition in its May and October draft. At a CMI meeting in Madrid, Croatian delegation together with FIATA proposed that the performing party should be limited to a person that physically performs. However, the American delegation wanted to add or fails to perform in whole or in part. They thought that if somebody fails to perform in whole, that means that he undertakes. So the whole is equal to undertakes. What about the Privity Rule? A contract cannot effectively confer rights or impose duties on those who are not party to it. So at that time, International Chamber of Shipping argued that the instrument should deal with the liability of the contracting carrier only and should not create a right of suit for cargo interest against any performing carrier's parties. World Shipping Council and the Transportation League joined, suggesting that the contracting carrier alone should be liable for any cargo loss or damage. What is very important that lies behind these two requests is that International Chamber of Shipping covers 80% of the world's fleet. World Shipping Council operates 90% of the global liner ship capacity, and Transportation League is a major Transport Industry Organization in the United States. But there was criticism of that initiative. They say the practical effect of these suggestions would be to leave cargo entries without an effective remedy whenever contracting carrier was insolvent or otherwise not amenable. In addition, preemption of bailment and tort law. That means that these two concepts should be removed. And this is an interesting comment. Professor Zunarelli at the time, at the meeting, commented, every regime that provides for the channeling of liability also includes mandatory insurance, which does not exist in this context. I would like to emphasize the last word, does not exist in this context. So CMIA December draft had this definition, performing party means the person that physically performs, and put the additional words which was requested by American delegation in square brackets, or fails to perform core in part. So Untitled took over and produced the same definition in the April draft. But when eventually the rules came out, the thing was much more complicated. So we have the carrier who is liable and is vicariously liable for all these parties. Then we have the carrier, the performing party, and on top of that, maritime performing party, which means a performing party to the extent that it performs or undertakes to perform any of the carrier's obligation during the period between arrival of the goods at the port of loading of a ship and their departure from the port of discharge of a ship. They added as well that an inland carrier is a maritime performing party only if it performs or undertakes to perform its services exclusively within the port area. Now we got a bunch of other parties. So liability of the maritime performing parties. And limiting of maritime performing, liability of maritime performing parties in trying to define the area of application. So the maritime performing party performed its activities with respect to the goods in a port in a contracted state, and that occurrence that took place during the period between arrival of the goods at the port of loading of the ship and their departure from the port of discharge from the ship, while the maritime performing party had custody of the goods at any other time to the extent that it was participating in performance of any of the activities contemplated by the contract. What does it mean? So the goods arrive at the port of loading, then the goods are carried to the port of discharge, they leave the port of discharge, and this is the operational area of the maritime performing party. If carrier and the maritime performing party are liable, then the liability is joint and several. So what is the idea behind the instrument approach? Convention drags into its regime parties not privy to the contract of carriage, here of marriage maybe, but it's contract of carriage. So maritime performing party gets protection, defenses and limits against claims in tort, but at the same time it gets all the obligation to third parties on convention terms. So actions in tort are banned if whether or any actions which are whether in contract, in tort, or otherwise, they are all now subject to the convention. So what happens in practice? If we have this container, it has to be discharged. So contractual carrier enters in a service agreement with the performing party, which is the stevedore. So if the container is damaged, the bill of lading holder could sue the contractual carrier, but could sue performing party, the stevedores, which physically performs or undertakes to perform. Now, the problem is that the parties of the service contract might have a number of claims and defenses related to the contract. For example, the stevedores did not show up because the advance part of the price was not paid, or there is a large outstanding debt on the ship owners, or the ship owner failed to secure safe working condition, or failed to advise the stevedores on time, or omitted important information on cargo properties, and so on and so forth. However, the bill of lading co-holder, means the cargo interest, they say, I don't care about any terms and conditions of the service contract. I sue you, the stevedore, as a performing party under the convention. You owe me the same duty as the carrier. So you can get all the parties sued along the chain of performance of carriage. Which is now what would be the amendments? We have compulsory insurance for liability in tort and contractual liability for passengers and crew. The idea is to cross the red line and have compulsory insurance for contractual liability for cargo. There are a number of conventions which use the mechanism of compulsory insurance, and IMO guidelines recommended to the ship owners. A European directive is mandatory and asks insurance for maritime claims, which include claims for the cargo claims. And then there are charterers. The charterers would not hire a ship if there is not proof of insurance for liability for the cargo. So P&I insurance is not in place. So shall we come back to the comment which we mentioned before? So the mandatory insurance did not exist in this context, and the trick is now of this proposal just to take it and bring it back to the context of the Rotterdam Rules. Is that a problem? Not so, because there are 53,000 merchant ships trading internationally, and the P&I group consisted of 13 P&I clubs, provide liability cover for approximately 90% of the world's ocean-going tonnage. Not only that, the charters are insured as well. The pool and the insurance layers, structures for chartered entries are identical to those in place for owned entries up to the cover limit. That insurance plan covers up to $3 billion. So we can channel liability towards the ship owner, the registered ship owner. But the bill of lading holder, the cargo interest, would always have a claim against the ship in red. So you will just see how complicated is that under the Rotterdam Rules. What they say, if no person is identified in the contract of the contractual particulars as the carrier, the registered owner of the ship is presumed to be the carrier. Fine and easy. Now the drama starts. Unless it proves that the ship was under bareboat charter at the time of the carriage, and it identifies the bareboat charterer and indicates its address, in which case the bareboat charterer is presumed to be the carrier. Alternatively, the registered owner may rebut the presumption of being the carrier by identifying the carrier and indicating its addresses. The bareboat charterer may rebut any presumption of being the carrier in the same manner. It looks like a good ping-pong match. The ball goes in one court and another court, and we are waiting for the outcome. It's not all. If a carrier is identified by name in the contract particulars, any other information in the transport document relating to the identity of the carrier shall have no effect to the extent that it is inconsistent with the identification. And here we go again. Nothing in this article prevents the claimant from proving that any person other than the person identified in the contract particulars or the ship owner is the carrier. Now, a lot of assumptions, lot of things to prove. How it works in the practice. Cargo is insured on the one side, and liability for the cargo is insured on the other side. So who could be insured? The ship owner, the bareboat charterer, time charterer, voyage charterer, and ship's manager. They all have P&I liability cover for their liabilities under the contract of carriage. Now, we can even channel the liability against the charterer and always against the ship, provided the charterer is designated as carrier in the bill of lading and particulars of approved insurance policy are displayed so that everyone who uses the ship can see that the charterer, who is the carrier, has proper insurance in place. So we can channel liability towards the ship owner or towards the charterer, as the draftsman would eventually decide. But the novelty is that with the claim against the ship, the cargo interest will get direct action against the insurer. So forget all the stories about the charterer's assets, whether they are available or not, whether they are sufficient or not, who is going to pay which party is liable, and dragging all these various parties into the liability scope of the convention. Here you have just one party, that's the carrier. You sue the carrier, and on the other hand, you can sue the insurer. So the money is there, which will eventually cover your cargo claim. Now, this is what Diana and myself, we thought that this should be a separate presentation, but in a nutshell, we shall go quickly through that to make the final point and maybe present it in more details at another occasion. So this is the chapter on jurisdiction in the Rotterdam Rules, which are copied basically from the Hamburg Rules. And they are so complicated and illogical in many ways. For example, here you have a agreement on jurisdiction, but claimant could choose any of these places above under A, and again, even though he has agreed or accepted or has in the document the jurisdiction clause, he can choose any of these places to start proceedings. Especially, there is a special provisions for the volume contracts, choice of agreements. So if maritime reforming party sued, so-called consolidation and removal, if there are more actions against 2 or 3 parties, recognition and enforcement, then arbitration proceedings for non-liner transportation, and all of these rules are optional, so a country could accept it or not. So what's the way forward? The tide has changed. The ship owners in a bulk, whether wet or dry, do not have any more an upper hand. And to the contrary, in many jurisdictions, the courts are biased against the ship owners, and they protect local importers. So the idea is to go back in the past, in the times of Lex Mercatoria, when the merchants were choosing their tribunals to decide the disputes among them. So forum designated by the jurisdiction clauses and arbitration clauses should always prevail. The only exception would be the liner trade single contracts, which usually call for the jurisdiction of the court of headquarters of the carrier. And there, a alternative jurisdiction should be allowed, maybe agreed place of delivery or something like that. And in the end, maybe a arbitration center could be established for the purpose of this convention, which then would resolve all the disputes under the convention. So, thank you. That's it.
Thank you very much, Petar, and Diana, who is a co-author of this presentation. Our next